Okay, welcome everyone to the first webinar from the section of Civil Rights and Social Justice of the 2018-19 bar year. Over the last year, our goal has been to rapidly respond to government actions that may impact civil liberties and civil rights by offering free webinars, commentary, podcasts, social media posts, and other information from our subject matter experts. We encourage you to check out our section website, www.americanbar.org/CRSJ, our Facebook page, our Twitter handle @ABA_CRSJ, and our YouTube channel for more news and information and replays of our great programming. And if you like our work, we invite you to become a member of the section and collaborate with us on upcoming projects. During today's program, if you're so inclined, you can ask questions of our panelists by finding the questions box on your right-hand side panel and typing in your question. We'll have a few minutes at the end that will be reserved for questions. We also have included two handouts in the handout tab of the drop-down, and we will share both the recording of this program and our handouts and the slides after the fact in an email. We'll be sharing all of this with everyone, and you'll be able to share it with your networks as well. So we thank you in advance. And please feel free to leave us feedback or to ask questions to follow up. So the section is thrilled to bring you today's program on gerrymandering and the new Supreme Court. Where do we go from here? I'm going to turn it over to Lynn Chan and James Perez, two of our co-chairs for the CRSJ Fair and Impartial Courts Committee and our moderators for today's panel.
Thank you, Paula. Our first panelist is University of California, Irvine Law School's Professor of Law and Political Science, Richard Hasen. Professor Hasen is a nationally recognized expert in election law. He has authored many books, including most recently the book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. Our second panelist is Kathay Feng, the Executive Director of California Common Cause, a California-based nonprofit dedicated to ensuring fairness in our electoral process. California Common Cause, under Kathay's leadership, has championed election and redistricting reforms, government sunshine and accountability laws, campaign finance reforms, media access, and the voting rights of traditionally disenfranchised communities. Kathay also wears a second hat, serving as the National Redistricting Director at Common Cause. So today's panel is about gerrymandering. So our first question is for Kathay. Kathay, can you tell us about what redistricting is and explain what gerrymandering is in that context?
Sure. Thanks, Lynn, and thanks so much to the ABA for hosting today's seminar. So let's start a little bit with some redistricting 101. This is a process that takes place usually every 10 years, right after the census happens, in the years ending in 0. So this year it would be 2020, and then in 2021 we'll have a redistricting process. The reason why we do redistricting is that we're trying to get the districts to all be approximately the same number of people within each district. So for congressional districts in each state, there will be a number that's determined to be the correct proportion of people. Generally speaking, it's around 650,000 to 700,000 people. They'll have an exact number for each state, and they're just making sure that each of those congressional districts within a particular state have the same number of people. Sometimes redistricting happens throughout the decade. Sometimes that's because of litigation. Sometimes that's because of interested incumbents who are trying to improve their odds of being reelected. But generally speaking, this is a process that happens once every 10 years right after the census. Now, what is gerrymandering? Gerrymandering, or maybe more aptly, gerrymandering, is a term that refers to redistricting when it's taken to its extremes to protect incumbents, to protect parties, or to protect a particular racial group. The name was coined because Massachusetts Governor Gerry from the Founding Fathers created and signed a particular manipulative map that ensured that Patrick Henry would not have a chance at running for Congress. An editorial writer coined the term Gerry from his name and salamander to become gerrymandering.
Okay.
So we talked a little bit about,
Oh, okay, go on.
No. So we talked a little bit about gerrymandering. There are, in fact, three kinds of gerrymandering or gerrymandering that we usually look at. One has to do with racial protections, one has to do with incumbent protections, and one has to do with partisan protections. So racial protections are when one group that's in control of the redistricting process, and in most states, that means that it is the state legislature that is drawing its own lines, and it's also drawing congressional lines, sometimes with a significant amount of input from congressional incumbents, that they're looking at where racial groups are, and they're trying to make sure that somehow, a group that they are invested in is protected. I'm going to use some examples from California because I think that these kind of point out how bad it can get. So in 1991, in California, the districts were actually drawn by our courts. And so in an example of sort of an entity that wasn't particularly interested in trying to racially gerrymander, they looked at where there were populations, significant populations of Latinos, and in this map you see them in the darkest of greens, and they created a district that would ensure that Latinos had a chance to elect a candidate of their choice as per the Voting Rights Act. But in 2001, when legislators had the opportunity to draw their own lines again, the legislators ensured that a particular congressional member who was afraid of a Latino challenger could continue to run in this seat by carefully excising Latinos from the district and adding large communities of Caucasian voters to the district so that they were diluting the Latino opportunity to elect candidates of their choice. So here you see in red large swaths of Latinos who are removed from the district, and here in purple where high percentage of white voters are brought into the district, thereby protecting the incumbent from a Latino challenger. Now, it's a little bit mixed oftentimes with an intent to try to protect incumbents. So in this instance, when we were looking at this district, the incumbent was a congressional member named Howard Berman. And as it turns out, Howard Berman's brother, Michael Berman, drew the maps for every single congressional member. And he took a little protection fee of $20,000 from each congressional member. Many of them confessed to the newspapers that it was a low price to pay for security for the rest of the decade. And he drew lines to protect each one of them. And in this instance, Michael was drawing these lines partly to ensure that his brother was protected from a Latino challenger. So you can see how quickly race gets mixed in with the politics of incumbent protection. And the last kind of gerrymandering is party protection. And so this is what we're seeing getting litigated, in particular in this most recent Supreme Court round of cases. There have been several cases that have come before the Supreme Court to challenge partisan gerrymandering. There are plenty of examples of both Democrats and Republicans, depending on who is in charge of the state legislature, expressing thoughts out loud about how they're going to bury the other side 6 feet deep. For North Carolina's Republicans, they pronounced in open hearings that they proposed to give a partisan advantage to Republicans, and they would have drawn it with 11 Republicans and 2 Democrats, but they just couldn't squeeze another district out, so the best they could do was 10-3. What's significant is if you look at the percentages within some of these states, so in North Carolina, the lower pie chart, When you look at the statewide votes, they're really split almost 50-50 between Democrats and Republicans, right? But the way that the state legislature has drawn the lines for congressional districts, the distribution is skewed so that Republicans have a significant share of the congressional seats, even though they only have about 50% of the statewide votes.
Kathay, if I could ask, is there a tendency, we're talking about Democrats and Republicans here, is there a tendency for gerrymandering to increase the dominance of major parties over minor parties? How does the existence of third parties play into gerrymandering?
Oh, well, there is oftentimes a tendency, not always, but there's oftentimes a tendency to have the largest party essentially squeeze out the second largest party wherever possible to minimize their ability to elect candidates of their choice for the entire decade. When it comes to third parties or an increasingly large percentage of voters who are not declaring with any party, they're unrepresented in this process altogether when it's the state legislature drawing lines, largely because they don't have a seat in the legislature that's going to be large enough to represent them at the negotiation table. And because it's oftentimes the majority party that's drawing the lines, they're sort of doubly discriminated against.
Great. Thank you, Kathay. So Kathay obviously works as an advocate against gerrymandering. Let's turn to Professor Hasen, who's an election law expert and who has studied these issues. Professor, what do you think? What are your thoughts on whether courts should get involved in regulating gerrymandering?
Well, let me just join with Kathay in saying how great it is to be here, and I'm glad you're putting on this seminar. This is a really important topic, and it's a really timely topic because we've had just a slew of cases, and there's a lot of there are a lot of questions about what's going on, and so I think this is a great opportunity to have this kind of discussion. And on the question of whether courts should get involved, that has been the key question for the last couple of decades. And just to kind of set the stage for our discussion that's going to come up about what's going on now, I think we have to go back in Supreme Court history, starting in 1986, when the court decided a case called Bandemer versus Davis, which involved gerrymandering in Indiana. And there, the court seemed to put forward a standard to say sometimes when you draw lines, you take party into effect too much, it could be unconstitutional. But the standard the court came up with was so difficult to meet that from 1986 to 2004, there was never a successful gerrymandering challenge. And so the Supreme Court revisited the question in 2004 in a case involving Pennsylvania's congressional districts, a case called Veith versus Jubeler. That was a case where the court divided 4-1-4. And going to your question, 4 justices, led by Justice Antonin Scalia, the foremost conservative members of the court, said, there are no standards. Of course, you have to take party into account when you're drawing district lines because you want to group people with similar interests together, and party is one way that people are thought of as having similar interests or similar ideas. And we don't know, Justice Scalia said, when taking party into account goes too far, that there are no what he called judicially manageable standards to make that determination. In technical terms, what he said was that this was a non-justiciable political question, meaning that courts can't get involved. Even if gerrymandering is unconstitutional and no one should do it, it's not for the courts to say, which would essentially leave it to the political process, meaning that there wouldn't be much regulation of this at all. But that was not a majority opinion. That was Justice Scalia speaking for 4 justices. The foremost liberal justices on the court said, no, these cases are justiciable. There are standards. And in fact, the justices came up with 4 different standards that they said could apply to determine when you've taken too much partisanship into account in drawing your lines. And standing in the middle of the court was Justice Anthony Kennedy. And Justice Kennedy said, I agree with the liberal justices that these cases are justiciable. They can be heard by the courts. But I agree with the conservatives on the court that every standard that the liberals have come up with and every standard that the litigants have come up with in this case and in the earlier Bandemer case don't work. They don't work to separate permissible from impermissible consideration of party. And so what you really need to do is think about it some more. And he suggested 3 areas where we might think about it. One, he said, we can look at history. Is there something we can learn historically from when gerrymandering goes too far? Second, he said, maybe we should look to computers. Maybe computers can help us to get some better data to figure out when partisanship goes too far. And he said the last place you might look is the First Amendment. Maybe the problem here is not about treating people unequally, but about punishing people because of their political beliefs. And so for the last 15 years, or almost 15 years since that Veith decision, we've been struggling with this question: is there a standard? Is there a standard? And I think that among advocates, there's a belief that there are a number of standards that the courts could apply, that things are getting worse. Among many political scientists, some think we're not quite there yet. We need more data to be able to decide when something goes too far, or this really should be left to the political process. And so I think there's a lot of disagreement, and no doubt as we talk about what's happened in the last year and what's going to happen, I think we're likely to get some resolution of this question from the courts within the next few years.
Great, thank you. So it sounds like the conversation has moved largely from whether or not courts should be involved in the first place to what is the standard that courts should be judging gerrymandering by. Is that correct?
Yeah, I think that's right. And so, if there are kind of 2 questions. One is, who can bring a claim? What does a claim look like? And we got a little bit of information about that from the Supreme Court last year in a case called Gill versus Whitford, who has standing to bring the case. And then, assuming there are people who have standing, assuming there are people who've been injured by this drawing of district lines, what's the standard going to be? If you want to kind of walk you through those cases.
Yeah, I think that would be a good transition into my next question, which is, this past term, the Supreme Court decided 3 gerrymandering cases. One, which you already mentioned, I think probably the most known, is Gill. The second was Benisek, and then the third was Common Cause. Can you kind of just walk us through each of those cases? What the issue was, what was the holding of the court? I know in at least in one of those cases, the court sent it back down, and kind of give us your insight into those issues.
Sure, and they've actually all been sent back. So we came to the end of the Supreme Court term, and everyone was expecting that we were going to get a major ruling on gerrymandering, probably in the Gill versus Whitford case. This case was a case out of Wisconsin. It involved state legislative districts, and the claim was it was not quite as blatant as what Kathay described going on in North Carolina. People didn't get up there and say, we're gerrymandering for partisan reasons, but it was considered, if you looked at different measures of partisanship, to be one of the most partisan plans. And the claim was that Republicans in the state had drawn these lines to favor their party, and they had done so in a way that led to this kind of asymmetry where Republicans could get a minority of votes among voters in the state, but get a majority of the seats. But it wouldn't work the other way, where Democrats could get a minority of votes and get a majority of the seats. And the whole case was really geared up to provide a kind of a new standard for measuring partisan bias, a standard called the efficiency gap, which was created by a political scientist, Eric McGee, and a law professor, Nick Stephanopoulos. And this standard was adopted in part by the lower court as a way of trying to come up with a way of drawing a line between what's permissible and what's not. Case got argued October 3rd, the very beginning of the Supreme Court term. And we waited and waited for months and got nothing. Everyone thought, Justice Kennedy's going to decide. And then, somewhat surprisingly, the court decided to add another case on the same issue, a case called Benisek versus Lamone. It comes out of Maryland. It differed in a few ways from the Wisconsin case. First, it involved congressional districting rather than state legislative districting. Second, it involved Democrats doing the gerrymandering rather than Republicans doing the gerrymandering. And also, it involved a First Amendment theory, which I mentioned a few minutes ago, more than an equal protection theory. So that case was argued. and it was clear from the oral argument in that case that the justices were no closer to deciding anything. And while these cases are arguing, the North Carolina case, the one that Kathay mentioned, where in a 50-50 state, 10 of the 13 districts were drawn to favor Republicans, that case was waiting in the wings to see what was going to happen. So we get to the end of the term, and Chief Justice Roberts writes an opinion for the court, which essentially says that the problem in the Gill case that the plaintiffs had was that they were trying to challenge the gerrymandering statewide, and that what you really need to do is challenge it district by district. And so they sent the case back for a further determination based on district by district lines. And he was very careful to say, even if the lower court finds standing, we still haven't addressed the question of whether there's a judicially manageable standard. So that question is still pending. But the standing question comes first. But almost all the justices agreed on the standing question. Justice Kagan, for the 4 liberal members of the court, adopted the First Amendment theory that Justice Kennedy had suggested back in 2004 in that Beef case, and says, here's how you should do it. And 2 important things about what Justice Kagan said. Number 1, Justice Kennedy didn't join it. If he did, there would be 5 justices coming up with a standard. Justice Kennedy said nothing, and we now know, a couple of days later, he retires from the court. So he wasn't ready to pick a standard and leave. The other thing we know is that Chief Justice Roberts distanced the court from what Justice Kagan said in her decision. And he said, the opinion of the court is this one and none other, very pointedly saying we're not adopting this. In the Benisek case, what we saw was that that was up on a preliminary injunction, and the court, everyone in the court agreed this came too early. Came too late. It was already too late for a preliminary injunction. Send it back to figure out whether there should be a ruling on the merits and think about all of these issues. And that case is pending. And the North Carolina case was also sent back, and they said, look at this in light of Gill and figure out standing. And then just to finish this up, a couple of weeks ago, the lower court, this is heard by a 3-judge district court with a direct appeal to the Supreme Court, the lower court in the North Carolina case, this is the Common Cause versus Rucho case that Kathay mentioned, the lower court in that case issued an opinion that was almost 300 pages that found standing under both the equal protection theory as well as the First Amendment theory, and also adding a third theory about the elections clause of Article 1, which if we have time, we could talk about that one too. The court said they're standing in these cases, and the court found that it was a partisan gerrymander under all 3 of those standards. And they ordered the drawing of new districts, and somewhat shockingly, they said maybe we should draw these districts now for the 2018 elections. The reason that was shocking, there had already been primaries. We were just days away from the printing of the ballots for the general election. And so the court asked for a briefing on what should we do now. And the Common Cause plaintiffs and the League of Women Voters and the Democratic Party, all the plaintiffs who complained about this said, it's just too late. Let the 2018 elections go forward as they are. But now the parties are fighting over whether there's going to be new lines that are drawn. And I just learned from Kathay that the state has gone to the Supreme Court, and it's trying to stop the redrawing of these lines. Right now, the Supreme Court is shorthanded. If this gets to the Supreme Court with 4 liberals and 4 conservatives, the court might deadlock, which would leave the lower court opinion in place. Might get there a little later. If Justice Kavanaugh is on the court, you might end up having a 5th vote that could go one way or the other. So that's where things stand. We thought Justice Kennedy was going to resolve all this last year. He was the swing vote. He's now gone. If Chief Justice Roberts is the new swing vote, then that doesn't look good for those who expect federal courts to get involved in these cases.
Thank you. I just have one follow-up question for you, Professor Hasen. I think you mentioned the last time that the court had took a gerrymandering case was in 2004. Is that correct?
Well, there were some cases in between, but that was the most important one. There was a case in 2006, for example, involving Texas deciding to draw districts in the middle of the decade, what was called a redistricting. That was a case called Lulac versus Perry. But the 2004 case was the most important of the partisan gerrymandering cases, until we got to the Gill opinion this past term.
Okay, do you foresee or do you suspect that the court has more of an appetite to take these issues head on, given that this last term they accepted 3 cases on gerrymandering?
So I'm going to say no, but I think that this is kind of a technical point, but I think that the technical way in which these cases get to the court really dictates what the court does. So ordinarily, when somebody challenges an election law or challenges any other law in federal court, it goes to a federal district court judge, a single judge, then it gets appealed to the relevant circuit, 5th Circuit, 9th Circuit, whatever, and then the Supreme Court can get involved when someone files a cert petition. Cert petition is completely discretionary. Either the court takes the case or it doesn't take the case. It's really up to the court, and it means nothing when the court denies cert. The Supreme Court has said cert denial means nothing. These cases, or at least some of these cases, pursuant to a congressional statute, come up in a different way. They're heard initially by a 3-judge federal district court, which is made up of 2 district court judges and 1 circuit court judge, with a direct appeal to the United States Supreme Court. Direct appeal to the United States Supreme Court. And if the court decides to not hear the case, that means that the lower court got the results right. The court dismisses it, or if the court summarily affirms, it means the lower court got it right. Doesn't mean the reasoning is right, but it means the lower court got it right. So in the Gill case, the lower court had found, this is the first time in one of these cases, that Wisconsin's drawing of state legislative districts was a partisan gerrymander. So if the Supreme Court didn't get involved in that case, that would have been a holding on the merits that partisan gerrymandering cases can be heard and sometimes can be won. So the court couldn't let that happen because nobody knew what the standard was going to be, so they had to take that case. In the Benisek case, they didn't really have to take that case because it was up on a preliminary injunction. My guess is that either Kennedy wanted to hear it, or maybe Chief Justice Roberts was thinking, if something's going to happen in these cases, I'd much rather have a case where we find both a Republican and a Democratic gerrymander. That would look a little bit better. So I'm thinking that's what may have happened there. But now we've got this North Carolina case. In this North Carolina case, the lower court found under 3 different theories that there's a partisan gerrymander. I can't imagine the Supreme Court won't take the case. It might not take it yet. It might wait for there to be a remedy and a new lines drawn. But it's going to have to take that case because there's going to be at least 4 justices who are going to want to hear that, and they're going to hope that the 5 conservatives on the court, if that's what we end up with Justice Kavanaugh, are going to finally put the nail in the coffin and say that these kind of cases can't be heard in federal court. Don't know that that's for sure going to happen. We don't know for sure that Judge Kavanaugh is going to be confirmed. If the Supreme Court remains shorthanded, then the lower court ruling could stand temporarily, but eventually the court's going to have to get involved, and because these are coming up from 3-judge courts, the Supreme Court feels a special obligation to get involved because it knows that if it does nothing, people will rely on what the lower courts did as though it were a precedent of the Supreme Court. So that really puts the pressure on for the Supreme Court to hear those cases.
So, Rick, you mentioned something in your discussion about last term. You mentioned something called the efficiency gap. So, Rick, would it be possible to explain what that is? And I think for both Rick and Kathay, is it your view that the efficiency gap analysis is dead, or do you see people in the field using that as a measure for gerrymandering?
I think Kathay should probably field that first, since it's been her. It's played a prominent role in some of the litigation she's been involved in.
Yes. So the efficiency gap, it is a mathematical measure that attempts to try to measure when a certain number of districts have been cracked or stacked in favor of a party, so that one party has a very efficient distribution. So the majority party has an efficient distribution of their voters, so they can maximize the number of seats that they can hold on to. But the other party has an inefficient distribution of voters. So in other words, generally speaking, what it means is you're packing as many of the minority party into a few districts, and then the majority party is spread out over more districts, right? So it is a measure that they were hoping would give the courts a single number that they could look at for each state, and then using that number, they could decide sort of like a speed limit. If it's above 55, then it's too fast, or 65, or whatever the court decides. What I would say is that there's a number of different approaches. Each one of the cases that Professor Hasen has outlined presents a different approach, right? So certainly the Wisconsin case was presenting this mathematical approach, and think of it like a speed limit, right? And the courts haven't yet said at the Supreme Court level yes or no to that. But they are nervous about the math that they're not sure they understand, and they're also not sure where to set that limit, and they're not sure that they're the right ones to set the limit. So the other cases coming out of Maryland and North Carolina present theories that are more grounded in First Amendment. And generally speaking, then we're looking at a mix of factors such as intent, the statements that legislators make when they're proudly proclaiming how they're going to crush the other side, things like that. So there's a lot of smoking gun evidence, and sometimes it's also about they're purchasing hotel rooms across the hall from or across the street from the legislature and making people sign non-disclosure statements as they secretly negotiate what those lines are going to be in order to, again, crush the other side. So that kind of intent evidence is what we think may get the Supreme Court's nod, in part because it's more familiar to them, right? This is an examination of facts, and then there may be some additional information that they're going to be open to in terms of potential impact, but not to ground it in the math. Your question about whether the efficiency gap can be used by practitioners, though, is a whole different one, which is outside of litigation. There are a number of states that are looking at the efficiency gap as potentially a stress test. So after lines have been drawn, or draft lines have been drawn by the state legislatures, can you run it through a series of stress tests, the efficiency gap being one of them, to indicate whether or not the lines have been drawn in a fair way to both parties? And so certainly one possibility is that we're going to see the efficiency gap have a rise just in practice outside of the realm of litigation.
Yeah, I would just add that even in the Wisconsin litigation, neither the plaintiffs nor the court saw the efficiency gap as sort of a single number that's going to resolve all these cases. It was a factor to consider. And so even though Chief Justice Roberts at the Gill oral argument sort of derided the test as what he called sociological gobbledygook, which got a little bit of some notoriety for it seemed like a kind of anti-scientific approach of the Chief Justice. I don't think it's dead. I think it's one factor. And importantly, as McGee and Stephanopoulos have pointed out, there are other measures of bias. And if you look at the measures of bias in cases like Wisconsin or in cases like North Carolina, they're all pointing in the same direction. So it's not as though there is a single holy grail. There are various ways of measuring this. You have to look at other things. For example, one claim that's often made by the opponents of having courts get involved is, well, there's a natural geographic clustering of Democrats in cities, so of course you're going to get these efficiency gaps because it's a naturally occurring feature of how you might draw lines to preserve cities and things like that. And there are ways to test for that. And so I do think that to the extent that courts are interested in tests of bias, the efficiency gap is one thing that they can look at, but it's certainly not being advertised as, you know, one magic number. If you're above 7, you know, you're breaking the law, and if you're below 7, you're just fine. It's not quite that simple, and it's not quite that simple across different states because different states have different geography, and so, you know, you have to kind of think about how that might be.
What does the prospect of a court with a Justice Kavanaugh on it mean for these types of cases?
Well, so if we think about the court in Veith, the court's changed a lot in its membership since Veith. Justice Kennedy is now gone. Justice Scalia is gone, right? Justice Souter's gone. So who's left who might say that it's non-justiciable? It's Justice Thomas. That's it. So, you know, we haven't really had Justice Alito, Justice Gorsuch, and Chief Justice Roberts weigh in directly on the question of whether these claims are non-justiciable. However, knowing their philosophies, their general conservative philosophies, I would bet, and I would say the same thing about Judge Kavanaugh, that they're likely to agree with the approach of Justice Scalia in the Veith case, that these cases are non-justiciable. So we're looking at likely 5 justices that would say federal courts should get out of this business. We don't know for sure, and oral argument can change things. And if ever there was a case to find that gerrymandering has gone too far, it's got to be North Carolina, where the legislative leaders say, we are drawing these lines for partisan reasons. This is a partisan gerrymander. Now, you might wonder, why were they being so candid about what they were doing? It's because they were drawing those lines because they were found to have committed a racial gerrymander. And they were trying to say, oh, this has nothing to do with race. Never mind the fact that more than 90% of African-American voters in the state are voting for Democrats. This is about discriminating against Democrats, not discriminating against African-Americans. No problem here. It's just all about party. But so now you have this, if the Supreme Court decides to stay out of Common Cause versus Rucho, the North Carolina gerrymander case, then in the 2020 round of redistricting, it's going to be anything goes. Any state that has a unified legislature, a unified state government, where that state government, rather than a redistricting commission, gets to draw the lines, is just going to do it to the maximum political advantage. And so maybe when Kavanaugh and Roberts see that, maybe one of them blinks and says, well, maybe this is going too far. We'll have to wait and see what happens. But if these justices follow what Justice Scalia said in the Veith case, we would end up with the federal courts being out of the business of even considering the policing of partisan gerrymandering, which would leave it to state courts, which would leave it to citizen initiatives that might establish redistricting commissions to the extent that those are allowed, and that's something we could talk about. But federal court's going to be quite difficult.
So I'll just interject that there was a late case. So before the Maryland case became Benisek v. Lamone, it was Shapiro and v. McManus, I think it was. And that case popped up in a weird way to the Supreme Court on the question of whether you could even bring a partisan gerrymandering case in the courts. The lower courts had said it's non-justiciable. And what's interesting is in a 9-0 opinion, delivered perhaps the last spoken words in the court by Justice Scalia, they said, actually, lower courts, you've got it wrong. You can't just kick it out because it's not entirely unjusticiable. We just haven't figured out what the standard is. It's unclear now that Justice Kennedy has stepped off the court whether or not the remaining 4 justices who signed on to, well, it's 3 because Scalia is now also off the court, but whether the remaining 3 justices are going to stick to that. But at least in one case very recently, 2016, I believe, they said you can't kick the case out entirely just on non-justiciable grounds. And so you still have to weigh the factors. The challenge is that they still haven't figured out what the measure is.
So does Brett Kavanaugh have a record on gerrymandering or voting rights?
There are some voting rights cases he decided.
He's from Maryland. What's interesting is that between him being from Maryland and Chief Justice and Roberts having a very unique interest in Maryland's geography, the last round of questioning, he went hard onto the distinction between hobby farms and real farms, and was lamenting the fact that when Democrats gerrymandered Maryland, that what they did was that they were putting all of these suburban, so-called farmers with real farmers. It's interesting. I don't want to be cynical, but it could be that maybe what they really need is to have a case like Maryland or another blue state gerrymander to find that there's not only been partisan gerrymandering, but here's what the standard is.
I would just add that although Kavanaugh has heard cases involving the Voting Rights Act, I'm not aware that he's heard any cases involving the drawing of district lines. So I don't think there's anything directly that we can draw here other than that we know he's quite conservative and we know what the track record is in the court among those justices.
Mm-hmm.
Thank you. and this question is for Professor Hasen. Outside of this U.S. Supreme Court, are there other ways to address gerrymandering? So are there alternatives to federal litigation?
Sure, and some of them, Kathay is probably better at speaking up, but let me just talk about state courts first. So not only does the federal Constitution contain provisions like the Equal Protection Clause or the First Amendment, which could, if courts wanted to, be the basis for finding that partisan gerrymandering is unconstitutional. States have their own constitutions, and state constitutions could potentially be read to provide more protection against partisan gerrymandering. Even if these cases are not justiciable in the federal courts, they could be justiciable in the state courts. And let me just talk about two examples. First, Pennsylvania. Pennsylvania was the subject of the Veith case in 2004, but we had this past year, the Pennsylvania Supreme Court, which I should point out is an elected Supreme Court, and the majority of the elected judges were Democrats, and the gerrymandering was done by Republicans. The state Supreme Court found that the drawing of the district lines for Congress violated the Pennsylvania Constitution and ordered through a special master the drawing of new district lines which many people believe could hand 2 to 4 additional congressional seats to Democrats. So very consequential use of state constitutions and state courts to get to that result. The other place I would look at is, again, back to North Carolina. Turns out that Supreme Court shuts the door on federal cases in North Carolina. Well, there's a possibility of bringing a state Supreme Court claim. And it could be, as it is right now, that at the time that such a case might be brought, the state Supreme Court might be majority Democratic in the state of North Carolina. And probably this is a subject for the ABA fair courts to talk about elected judges deciding these kinds of cases. But it's certainly possible that what's allowed under the federal Constitution, or what can't be policed under the federal Constitution, could be policed under the state Constitution by state courts. The other possibility is redistricting commissions, and I think on that, Kathay is much more of an expert than I am.
Yeah, so certainly about half of the states have the opportunity, because they have an initiative process of some sort, to try to change the lines through the initiative process. And part of the reason why you have a better chance of changing the process entirely through an initiative process is that it is very, very hard for legislatures to voluntarily give that power up themselves. No matter how well-intentioned they are, they always seem to hit that snag when it comes to actually passing the ring of power onto someone else. So in California, we were able to pass 2 initiatives in 2008 and 2010. The first one created a 14-person commission that drew lines for all of the legislative seats. And then the second time that voters got a chance to vote on it in 2010, they added the responsibilities of drawing congressional districts. So these 14 people came from 30,000 applications from the general public. The legislature only had the ability to strike names, a la a jury voir dire process, but they were not able to directly pick them. And so it's one of the unique examples of an entity that is made up of citizens who've been screened for conflicts of interest. They are not allowed to run for the seats that they're drawing, and they're not chosen by electeds themselves. They also don't include anybody who is currently serving in a congressional seat or state legislative seat. They were responsible for drawing all the lines at the congressional and state level for California. What's interesting is that they held over 100 public meetings. They were only required to hold about a dozen, but they went all out. And during those hearings, what people saw were screens where, as they were giving testimony, they could see the lines being moved live in front of them, and they could see that information being captured in real time and reflected back to them. And people could kind of watch this on their computer, or if they tuned into one of the California information channels. So all the deliberations were in public, and ultimately the final lines that were voted on were publicly displayed and processed through everything that had been provided through those public hearings, unlike legislative processes where there might be a set of hearings, but generally speaking, all the real deliberations and line drawing are done behind closed doors and in secrecy. So what's interesting is that in California, this process, it was very experimental when we did it in 2011, but because it turned out that there were a surprising number of people who were willing to apply and a surprising number of people, 20,000, who are willing to come and testify, a lot of people rated it as largely successful. There were, in fact, lawsuits that challenged the lines, and in unanimous decisions, 7-0, and these included in California majority of judges who are appointed by Republican governors, they affirmed the maps, and they said that, you know, this is fair to everybody, and in particular, the process has been more than fair. So what we see now is that in other states, 4 states in particular, there are now processes where they're challenging the redistricting processes that are controlled by the legislature. And we're likely to see on the November ballot in Colorado, Missouri, Utah, and Michigan efforts to try to create alternative systems. Michigan's is probably the most likely to kind of create something that is truly independent and a citizen-driven redistricting commission. And the other states create various levels of measures for what should be fair and not fair, and create some independence. In Missouri, they've actually adopted a standard that's largely the efficiency gap standard as their benchmark for what's fair and what's not fair, and they've got a nonpartisan state demographer who's going to be drawing those lines. So a lot of states are now embarking, as we get closer and closer to the next round of redistricting, in some process of trying to change their lines. We expect that even in 2020, there will be another handful of states that have an initiative process. In some cases, there are even ones like Pennsylvania that are trying to push for legislative changes, though that is a far harder road to take. And then I'll just say this. The last piece is that we are seeing so much more gerrymandering to the extent of kind of cementing partisan control, in part because it's a combination of extremely sophisticated software and the availability of big data, right? The ability to kind of look at your grocery shopping habits and your choices, you know, when you're clicking it through Facebook ads. And so we're seeing that increasingly, as legislatures are drawing their own lines, that they are successfully able to remove voter choice through the entire decade, right? Removing challengers or the ability for anybody to reasonably challenge before the primary or before the general election. So both within party and between parties. That's part of the biggest challenge. I'll say the other piece is this very messy combination of incumbent protection with the impact on racial communities, right? So we talked a little about North Carolina, and just as a small snapshot, right in Greensboro, North Carolina, there is the largest historically Black college, North Carolina A&T. It is 12,000 students, largely Black and brown. And the way that they drew the lines right through this university split the campus in half, right? Thereby not only removing the ability for students from that campus to be able to effectively organize and elect candidates or be a large influencer within a district, but in particular, students who are Black and brown from being able to elect candidates of their choice, right? So there's on a lot of different levels, gerrymandering is becoming worse and worse, and our hope is that the recognition that the Supreme Court has said in a number of cases, including the 2015 Arizona State Legislature versus Arizona Independent Redistricting Commission case, they've recognized that partisan gerrymanders are a serious problem. And they seem to still be signaling, we still think that there are 3 of the conservative justices that have signed on to the idea that it is justiciable. They might find 12 other reasons why they're going to get out of it, but at least we think that there is an opportunity, if the right case presents itself, for them to say, in these situations, in these circumstances, we're going to strike down this partisan gerrymander because it's just wrong.
Thank you, Kathy. We'll open it up for questions now. Naturally, the first question is about the Arizona redistricting case, and it's for Rick. The question is, can you discuss the significance of the first Arizona redistricting decision, and what are its prospects now that Justice Kennedy is gone?
That's a really interesting question. So let me just briefly say what the facts are there in that case. That was a case where Arizona adopted an independent redistricting commission by initiative, just like Kathy described. And the Arizona legislature didn't like it because they wanted to keep the power to draw their own district lines. And so they brought a challenge arguing that under the Constitution, it is the state legislature that is given the power to set the time, place, and manner for congressional elections. This is in Article 1. It says that state legislature can set the rules subject to congressional override. And the argument of the Arizona legislature was, it says the state legislature sets the rules. Now, there had been earlier cases, some about 100 years old, that said that when changes to the districting process are done by initiative, by voter initiative, that is okay, and that the term legislature really here in this context means the legislative process, not just the legislature. And so that you can get redistricting reform for congressional elections through the initiative process. This was a 5-4 decision. Justice Ginsburg, who I see is before us on the screen, Justice Ginsburg was the author of that opinion. She was joined by the 3 liberal justices and Justice Kennedy. A very strong dissent, one of the strongest dissents I can recall from Chief Justice Roberts in that case, saying, in this context, legislature means the body that is voted as the legislature. It doesn't mean the legislative process. This case is wrong. And so no doubt if Judge Kavanaugh is confirmed to the Supreme Court, let's say the Michigan measure passes and the Michigan Republican legislature doesn't like it and they bring a challenge, the lower courts are going to have to say, well, your challenge fails under the Arizona case, but maybe it goes up to the Supreme Court. And then the question for Chief Justice Roberts is going to be, how much do I respect precedent? How much do I want to get involved in this case? Because we know he thinks the case is only a few years old. We know he thinks the case was wrongly decided. Is he going to want to use some of his political capital and do this? If the Arizona legislature case were reversed, what it would mean is that all of those redistricting commissions that deal with congressional elections, as opposed to state legislative elections, would be unconstitutional. They could not draw those lines. So potentially monumentous decision coming in this context, but I don't know how aggressive Roberts is going to want to be coming right out of the box. There are going to be a lot of things that going to be a lot of pressure to overturn other precedents. You know, could think about abortion, affirmative actions, all kinds of things on the agenda. I don't know if this is at the top of his list, but it's certainly something we need to watch.
Thank you.
Thank you. So we're getting a lot of questions about where we go from here. So are there states that you view are ripe for state level partisan gerrymandering challenges, and where should we devote our energy?
Well, one thing to say is that it's 2018. So that means in a couple of years, this all starts over. It starts all over again. It's kind of shocking that, you know, just this year the court decided the Texas redistricting case. This was a case under the Voting Rights Act involving racial gerrymandering, you know, for lines going back to 2011, some of them. So this is all going to start all over again. Yeah. We only have you know, this election and the 2020 elections before we're going to have new lines, and by then we presumably will have some guidance from the Supreme Court as to whether or not there are going to be federal challenges.
Mm-hmm. There are some other cases that are percolating coming out of Georgia and Ohio, but what I would say is that it is correct that new cases launched now, unfortunately, are going to hit up right against the legislative process for drawing lines in 2021. And so it may be that courts will be very reluctant to try to step in if there's not a case that they're already looking at right now, because it creates an inconsistency in terms of, and maybe even a mootness in terms of the court looking at the case when new lines are about to be implemented.
I'm guessing that there are going to be plenty of opportunities to file amicus briefs in the Supreme Court in this coming term, in either the North Carolina case or who knows what else might be back. The Wisconsin case might be back. The Maryland case might be back. I think we don't know exactly how quickly these things are going to go.
We certainly would welcome a lot of those amicus briefs. If people want to get in touch with Common Cause, we'll make sure that you're connected with any one of the cases, the Maryland case, the Wisconsin case, or the North Carolina case, whichever one hits the Supreme Court first, or all three of them at once. And again, if there are people who are interested in helping out with any of the other cases, there are plenty to go around, including some challenges to some of the ballot initiatives. So there may be plenty of opportunities if people want to get involved.
So we have a question that I think is a good question. It's asked, and I put this to both of you guys. Do you have any thoughts about the possibility of challenging Utah districting on the basis of religious gerrymandering? The legislator in Utah are overwhelmingly members of the LDS Church, as are many or most holders of statewide officers in the entire congressional delegation.
That sounds like a question for Professor Hasen.
Well, I was going to say, it's not a question for you. I don't know enough about Utah to be able to say that, but I can say this about Utah. I was at a panel at the American Political Science Association meetings last week, where one of the presenters made the point that people sometimes say, well, we should just have redistricting done by computers. It should just be drawn randomly. We should have random districts. And if you did that in Utah, you'd actually end up with no Democratic representation at all, Democratic Party representation. Because if you just draw random districts, there are more Republicans than there are Democrats. You wouldn't have any, despite the fact that Salt Lake City is a majority Democratic city. You have virtually no representation. And so if you think about these states, you think about states that are essentially one-party states, where if you actually did things completely randomly, you might end up having no party, the minor party having no representation. And so I don't think people think that's a good idea. So we've got to kind of think about this in a sophisticated ways, and there are not going to be mechanical answers that are going to get us out of these difficult problems.
For folks who might be in Utah, what I'd say is that there is an initiative that is likely to get onto the ballot for 2018 to try to create an alternative process. Last piece is just that, it is possible that there's something to challenge based on religious discrimination. I think the challenge is that I don't know that it's particularly appealing to bring Utah as the example. So I think we might cast around for another example. Doesn't seem like it'd be fruitful.
Yeah, there is some interest in what to do about third-party challengers. In your view, is there a more fair way to protect those third-party challengers in redistricting? And what's the solution?
Well, so third parties have a really tough time with just about everything. Ballot access, if you look at public financing rules, they often tend to favor the major parties. There are different, we didn't have a chance to talk about this, but there are different ways. We don't have to use regular districts, single member districts to do our choosing of representatives. There are things like ranked choice voting. There are the use of multi-member districts with ranked choice voting. There is cumulative voting. There are different ways that we might get representation. And although there's right now a congressional statute that would prevent doing anything but single member districts for Congress, on the state and local level, there is the possibility, and some places have experimented with alternative ways that can help some representation of third parties, at least if not to be elected to office, at least for those people to have more influence over who is elected to office. And so, I think we're thinking more broadly about democracy and representing a whole variety of interests. we shouldn't necessarily be stuck with the model that is the most common one that's used right now in the United States.
Well, great. It is 11 o'clock. Thank you so much for your participation. And unless you have any concluding thoughts, we thank everyone also for attending.
Thanks so much.
Thank you.
Thank you.
Thank you very much.